Hello, and thank you for joining us on the Ask Andrew Show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal of Greater Toronto Area family law firm. And just like it says, Feldstein Family Law Group, we practice exclusively family law. Today is our special guest is family health lawyer Lisa Feldstein. And for those watching, you may wonder, are we related? Yes, and I do think she is the finest family health lawyer in the province. She's my niece, and she's a wonderful lawyer for anyone who needs someone in that area of law. And today we're going to be discussing third-party reproduction laws, meaning surrogacy and egg or sperm donation, and how these issues affect a family law matter. And thank you for joining us today, Lisa.
Thanks for having me. I'm actually surprised it took 3 seasons, but happy to be here.
Yeah, I think I just got a dig. So let's start with a question, which is, this is to me, and I know you've been telling me about these issues for years now, it's a very unique and interesting area of law. What brought you to practice in this area of law?
Well, I didn't even know it really existed as an area, but my first exposure was a law school class. When I took family law, I tried to make every class about health law. And so I had the opportunity to write a paper about a decision in which a lesbian couple wanted their friend to donate sperm. And because he was gay and over 40, the laws we have under the Food and Drugs Act, we have semen regulations. I don't know if you know that.
I didn't.
Semen regulations. As a gay man over 40, his sperm had to be quarantined for 6 months, and he wasn't happy with that. And so they actually challenged the regulations, and it resulted in a Court of Appeal decision that I wrote a paper about criticizing. And that was a bit sort of the first spark, the first exposure to this field, and opened my eyes to reproductive law and the role that lawyers can play in helping people build their families.
I mean, that sounds like a fascinating case. Are you saying that that happened to that gentleman because he was gay, or was that just anybody over 40?
Over 40 and gay, literally sperm donors are treated differently under that criteria. And the contrast in that case was I explored single women and also straight married couples. And my argument, a lot of it had to do with it's quite paternalistic, because a straight married couple wouldn't have to go through the quarantine process. And the rationale for that is that the woman's already been exposed to the risk. I argued, one of my arguments was it was quite paternalistic to say that a single woman, or in this case, the lesbian couple, couldn't decide to take on that risk for themselves. And the fact that it was literally had to be treated differently by the fertility clinics because of their either sexual orientation or marital status wasn't right.
So what year was this decision?
2007, quite a while back.
11 years isn't that far back. And is that still good law today?
I believe that it is, although there's been some advancements for sure in terms of how different families are built, and people with different sexual orientations are now treated much better than they were in 2007. We can maybe get into that of the birth registration piece for lesbian couples has definitely improved, but there are still quarantine requirements.
Okay. So then that probably is a good jumping point to what you just mentioned, which was the birth certificate requirements.
Yeah, so that's really a can of worms, because every jurisdiction is different. So when people want to make sure that the right names are on the birth certificate, it completely depends whether we're talking about surrogacy versus egg and sperm donation. Those are two different directions of how that unfolds.
Maybe you can explain that before you jump through your answers so the viewers can understand the difference.
Yeah, and it might make sense to actually just recap what surrogacy is. A lot of people don't even know what surrogacy is, or they think that it's illegal. So in Canada, surrogacy, it's legal as long as the surrogate isn't paid for acting as a surrogate. So it is perfectly legal. It's actually very common. And same with sperm and egg donation. They are both legal. You just can't compensate the donor for their donation.
Okay, so we just got a question on Facebook Live, and it reads, can a surrogate choose to keep a child that is biologically mine? And if so, what are my child support obligations to the child? Do I have any access to the child?
So rather than just give a yes, no, because in law, the answer is always it depends, but it really, there's a few layers to this. So thankfully that has, as far as I know, never happened in Canada. There's never been any case where a surrogate changed her mind. And there's a number of reasons for that. And one, so the question in this case suggested that the surrogate is not biologically related, which would mean it would be the person who's going to raise the child, maybe her egg or an egg donor, but not the surrogate. So we refer to that as gestational surrogacy. That's what's usually done. Most of the time, the surrogate is not related. It's not her egg. So that's a really important part for a few reasons. And one is it's commonly felt that a surrogate would have a harder time relinquishing a child if it was genetically her child and she carried it. So it's called traditional surrogacy. That's far less common. So in Canada, we have a combination of usually it's gestational surrogacy and the surrogates get independent legal advice. And most of the time they go through psychological counseling as well. And all of these things are checks and balances to help make sure people are psychologically fit to be able to carry someone else's baby and give it up and not want to keep it for herself. And typically, most surrogates will have already had children and be done completing their family as well. So they really know what they're consenting to when they agree. So there's lots of things that are already happening that aren't necessarily legal, but the process leading up to it to help reduce that risk. But to answer the question, if a surrogate did change her mind, I mean, it quite possibly could result in a lawsuit. But our laws in Ontario now actually say that surrogacy agreements are enforceable with respect to proving an intention to be a parent. So if there were a lawsuit and she entered an agreement and she signed it and she got independent legal advice, the parents of the child, and here I mean, they would likely be genetic, but not even necessarily, but the intended parents, that's the lingo, they would have the ability to rely on the contract that has been signed to prove they should be the parents, and she understood that was the intention.
And I guess that flows into what her access rights and what her child support obligations would be.
Mm-hmm. So
I'm guessing there would be none.
That would be my guess as well. So there hasn't been that case in Canada, but that would be my suspicion as well.
But here's the question that I would think of, because you're referring to Canadian law, in particular in Ontario. But if there was a surrogate who decided at a certain point in time that they made a mistake and they wish they could keep the baby before they've given birth, mm-hmm. What stops them from going to a different jurisdiction that would recognize them as a parent and giving birth in that jurisdiction? And then the habitual residence of the child is that jurisdiction, and they may end up as the parent.
Yeah, so the jurisdictional piece is huge. A lot of people think if they're from Ontario, they could just register the birth here, baby gets an Ontario birth certificate, and that is not true. It's the laws of wherever the baby is born, which is why I always tell people wherever the baby's being born, you need to speak with a lawyer in that province or that state to find out what's the birth registration process. So that's a really interesting question. If she did go somewhere else, I think they would have a lawsuit on their hands. Our courts here have actually been very flexible in Toronto at helping manage unusual, wonky jurisdictional surrogacy issues. Our courts have been pretty flexible, so it would be quite possible that they could actually still bring a case in Ontario to have themselves declared as the parents, especially if they did have evidence of the contract, if they were able to obtain DNA evidence or get that. But that would be very messy. Thankfully, so incredibly rare, though. I mean, like I said, we have these checks and balances of independent legal advice, psychological screening, surrogate not genetically related. So all of these things help avoid that. And this will be kind of a contentious point for sure, but some people will say that's why surrogacy should remain altruistic. That is currently being brought up again. We do have a politician who's bringing that debate back to the forefront. Should surrogates be compensated? One argument for not compensating surrogates is we want them to do this for the right reason and not have money influence their decision, which they may later regret and change their mind.
Yeah, you see, I'm not going to weigh into the political debate, but I could really see there being a problem when someone just decides to move somewhere else. And especially if they pick the right jurisdiction, I don't think that jurisdiction, when I say the right one, may even care what a Canadian court says. And that's the practical problem, that I would think that no matter how well you paper it, how well you do your job, if somebody wants to go to a place where there are no reciprocal laws with Canada, they may be out of luck.
Although you say that's the practical problem, but in practice, that would be
rare.
Astounding. I'd say that's the law school question, because by the time someone's a surrogate, she has attended so many medical appointments. She has been poked with so many needles and ultrasounds, blood work. She has gone through so much already to get to that point that would be highly unlikely anyone would go through the many steps of becoming a surrogate.
Okay, and I see we got another question that just came in on Facebook Live, and it's about surrogacy as well. Do I have any obligation to my surrogate? I know that I cannot pay her for carrying the child. However, do I have to contribute towards her medical bills, other costs associated with her being a surrogate?
Yeah, so that's a great question, and the answer actually applies across Canada, not just Ontario. So our law, the Assisted Human Reproduction Act, it says you can't pay a surrogate, but you can reimburse her. As of now, there is no list of what can be reimbursed. The government has been working on regulations, but the law's been around since 2004, and as of now, there's nothing specific. All the law says is there has to be a receipt, which means it's a pretty big gray zone of what is and isn't appropriate, and actually that goes into the contract. What gets reimbursed is negotiated, so the law does not say intended parents must reimburse the surrogate for X, but that's why we have that discussion as part of the contract stage, to ensure we have everyone on the same page. What can the intended parents afford to reimburse? What are they willing to? What does the surrogate expect? And make sure that everyone has the same understanding and that the surrogate is hopefully not out of pocket at all.
So I'm going to ask you another law school question then when we talk about expenses. I understand when someone says, well, there's going to be a cost for me to go get an ultrasound, or my back is hurting, so I may need more massage therapy now. I'm assuming those are clearly going to be more legitimate. Maybe not the massage, but probably.
Massage is in some of the contracts.
Okay. But how about the person who says, well, now my consumption of food is going to be higher. My consumption of utilities is going to be higher because I have to go to the bathroom more. You can sort of see the stretch of where someone is going to say, my consumption of everything is up. I need a new wardrobe because I'm bigger.
Yeah. And I mean, a lot of those are actually really not even controversial. Like maternity clothes goes into just about every one of these. But that's why it's the gray zone. There's a line somewhere. We don't really know where it is. And I once had clients that raised, what about air conditioning? If she's pregnant in the summer and she's going through hot flashes, will she have higher utility bills? Like you say, I don't hear utilities raised that much, but I have heard that. It goes in the contract. And the way some people deal with it, every contract is customized for the parties. But one way is they choose a monthly maximum. So they might say, we will reimburse you if you've got receipts, but let's try to keep this under control. So every month it will not exceed $2,000. So if it gets to that point, maybe it rolls into the next month, maybe not, depends how they craft it. But that's one way, or a global maximum to say reimbursements up to 10,000. But after that, there's really nothing more that needs to be reimbursed. Or it could be you have to seek permission for anything over $500. So I present options for my clients and they pick and choose what suits them best, and the surrogate discusses it.
I'm assuming the surrogate is the one who really has control of that portion of the deal more than the prospective parents, because it's obvious who is the one who is doing something voluntarily and is being kind, and the other one who is benefiting from that. So I would think usually the surrogate has more control over that process.
Yeah, and most of the intended parents don't want a surrogate to be out of pocket, and they want to be generous. And I think it's more with a stranger is keeping in mind, is this someone that may try to take advantage? But I have to say that's quite rare. And again, their law says there has to be receipts. So even if someone's pushing the limits, there has to be receipts. They would still have to be somewhat legitimate if you're producing a receipt. I mean, it's hard to imagine a justification for paying someone's rent or mortgage, for example, when they already have that expense.
I have caught in cases where people have created receipts to support their family law case. So you don't know what may be out there. Here's another question from Facebook Live. Do I have a right to attend a medical appointment with my surrogate? Do I have any right to make any medical decisions that will impact the baby?
Okay, so those are two separate ones. The first one, do I have a right to attend a medical appointment? That's one of the many things that actually goes into the contract as well. The law is pretty vague. We have some provincial laws in Ontario, and there are some laws that apply across the country. They don't get into that level of detail. That's where the contracts come in, is we discuss, what's your expectation? Do you want the parents at all of the appointments? Or sometimes parents literally live in another province. It's not realistic to go to every appointment. do they want the surrogate to be Skyping from the obstetrician's room? And I had one client, she was so worried that she would mistranslate medical information. She really did want the parents at every appointment, even though some of the appointments are 5 minutes. She just wanted to be sure the right information was translated, and she wasn't, they weren't relying on her to paraphrase medical terminology. So all of that goes in the contract. The trickier question, though, the second one, is about medical decisions for the child. And Ontario's law is pretty similar to the other provinces in that women have the right to control their own bodies. So surrogates, as long as she's still pregnant, has the right to control her own body, and it's her consent that would be required for any medical decisions. But that does also go into the contract. It's that part of the contract wouldn't be enforceable, but it helps everyone discuss what decisions might come up. What do we all want to see happen? So is a surrogate willing to undergo amniocentesis, a more invasive type of test? Would the parents want to maybe ask her to do that? Would she be willing? So we have those discussions, but there is an element of good faith because she can't be forced to undergo any treatment that she doesn't say yes to in the moment.
Well, that also makes me wonder, have you ever seen someone say if there's an end of life decision to be made because somehow the surrogate is in an accident, and whether or not the adoptive parent should have the power of attorney for personal care to extend the surrogate's life so that the baby can be delivered full term or close to full term?
I address that in every single contract, actually. I'm wearing my health lawyer hat when I'm doing these. So I ask that every single time. And then my clients and the surrogate, it's up to them. But yes, we have that discussion. And often it's not that the intended parents would be appointed as the attorney for personal care, only because so many other healthcare decisions might come up where that would not be appropriate for them to be deciding. But we specifically discuss what would happen if a surrogate were, on life support and it was proposed that it be withdrawn. Would she want to be basically kept alive on life support so the baby could be safely delivered? And if yes, we put that in the contract. We also will typically put it in that she will tell the person who would be her substitute decision maker. And there's some language in the Healthcare Consent Act in Ontario that recognizes what somebody's prior capable wish is. So I specifically refer to that section of the law saying this is intended to be her prior capable wish that would prevail in that circumstance. Somebody could make a power of attorney for personal care, documenting that as well. My concern is someone might intend to and never get around to it. So I make the contract as explicit as possible.
So then would there be a concern in that scenario that the person who holds the power of attorney disagrees with their prior wish and could say, no, I'm not going to follow the prior wish? And is there anything the surrogate could do?
So, well, in that case, the surrogate probably wouldn't do anything because that circumstance would only arise if she was mentally incapable. But the intended parents would be able to potentially do something.
Sorry, I meant the intended parents.
So they actually potentially could. So, for example, they would show that document to the healthcare providers, and the healthcare provider might say, now, there's actually under the Healthcare Consent Act, a healthcare provider can say this substitute decision maker is not complying with the law, with how they're supposed to make decisions as a decision maker. They could bring an application to the Consent and Capacity Board. There would actually be a hearing about it. So in that case, a doctor could initiate the hearing, the contract.
What if the doctor just says, no, I want to follow the instructions of the person with the power of attorney?
That would be tricky for sure. If the doctor didn't initiate that, I suppose the parents could still try some other things. Guardianship technically outranks power of attorney for personal care, although that would be a very, very limited scope guardianship they would be seeking of trying to get authority just for that specific situation. But it would be hard to imagine a physician ignoring a contract like that. And most doctors don't want to be caught in the middle of lawsuits. So taking it out of their hands into the CCB would probably be a prudent way to go, so it's not their decision.
So here's another question from Facebook Live that came in, which was, can you contract the location of the birth of the baby?
Well, that's a yes and no. Yes, it's in the contract, but does it always happen? A surrogate could deliver at 26 weeks pregnant and she's not yet where she intended to be because she didn't know the baby was planning on showing up early. None of us can control when the baby comes. So it does go in the contract in terms of the jurisdiction. So most of my clients, it will be some Ontario hospital, if they know the hospital, will name that as well. And there's usually some travel restrictions, and that's not intended to be oppressive, but intended for everyone to recognize that there are risks to travel beyond maybe not having the right healthcare system or being in an airplane or not being permitted to fly, Zika. There's all these reasons travel is a risk, but where the baby's born is very important because it affects becoming a parent. So we usually say, whether it's the whole third trimester or 30 weeks, we usually establish a time frame after which she'll at least stay in the province. Sometimes people like actually a radius. She won't travel more than X kilometers from a hospital. If that's possible.
It sounds like these contracts need to be very detailed oriented and try to envision a lot of potential issues that may arise between the surrogate and the parents. Is there a statement?
It's fair, and that's really what this comes down to, is they are really thoughtful, meaningful contracts. This is not the kind of contract where a signature on a page is all that's needed. Once in a while, people will call me and say they've basically made their own, or this person was a surrogate once before, so she's already got her contract. Can they come in, basically sign it, and I stamp my seal, and now it's official? And that adds no value because it doesn't account for the fact this is a new pregnancy, new parties entering into a relationship, and they are really customized agreements because all these little things that have the potential to become conflicts.
Now, here's the question that fascinates me, because we've talked about what goes into the agreements and the potential for them to be challenged, and that's what you're being mindful of. Are there any judicial decisions now challenging these kind of contracts?
Not much in Canada. So again, I think a lot of that goes back to, we've got all these great checks and balances. But in Ontario, we do now have a relatively new law, a little over a year. And what the law now says is these surrogacy agreements are not enforceable, except for being used as for proof of parentage. So unfortunately, that's not, I don't think that's good for surrogates or intended parents. I did submit something to the government when it was being deliberated, but I was not able to persuade them, as it turns out. But the agreements are not enforceable. So I find that concerning because that means both parties have the potential to enter a contract and then have no remedy. But the law does say it's enforceable with respect to parentage, which is the heart of these. If someone did change their mind, as unlikely as that is, then that could be enforceable. But all the other stuff, the way that it's worded, it's unlikely a judge would uphold it, which means it's good faith and it's trust. And it's the exercise of having these discussions to avoid conflict in the first place rather than retroactively taking someone to court. So the value is in the discussions, really. But every jurisdiction's different. Some are silent on whether they would uphold it. And some of it maybe wouldn't be upheld just because it may be considered sort of not appropriate or not consistent with public policy. So some of it, although it's agreed to, would not actually be enforceable.
And the two parents would be the two people that would appear on the birth certificate, and the surrogate would not. Is that correct?
That's the intention in every case. It depends on the jurisdiction, though. In some jurisdictions, the surrogate's name actually goes first, and then that gets rectified after the fact. In Ontario, we have a great province for surrogacy. In Ontario, when everything is done right, the surrogate's name never appears on the birth certificate.
Which probably makes life a lot simpler for the parents going forward.
And sperm and egg donors also, their names do not show up on the birth certificate whatsoever.
And weren't there some changes to the law with respect to sperm donors recently?
Yes, there are a number of changes. Bill 28, All Families Are Equal Act, changed the law so that now it's actually quite clear donating genetic material does not make someone a parent. So before, it wasn't that it was illegal, but we just didn't have that as clear as now the law actually specifically states being a sperm donor does not make you a parent. Being an egg donor does not make you a parent. Our law in Ontario has really moved towards intention versus biology or who carries the child. It's really about who intends to be a parent is a driving factor.
Okay, now when you say it's a driving factor, what I'm curious to know, is there a distinction between a sperm donor that went to a clinic and donated and there's artificial insemination versus a scenario where you have some people say, and they made a decision, whether there is an agreement or not an agreement, that this was supposed to be basically artificial insemination, but they made the baby in the old-fashioned way?
And the old-fashioned way is a perfectly legal way for sperm donation to happen. And actually the changes in the law recognize that. I was quite shocked when I read them. I thought, am I reading this right? That's that's actually being recognized, because you can see how incredibly messy that could get, especially if, even if there is an agreement, if that turns into a relationship, does that change the terms of the agreement? So technically in Ontario, going to the clinic does not change the legal status, but it helps an awful lot if there was a dispute, because then there would be some paperwork signed at the clinic to further support the intentions, and it would help support the fact that there's not a relationship between the parties.
So we could end up in a situation where you have the dad saying, I just, we had a discussion and I was just being a nice guy. And the woman saying, no, we just happened to have the baby and I want my child support.
Yeah, which is why these agreements are so important, and independent legal advice, because having an agreement where both parties have their own lawyer read it, give them advice, they know what they're signing, they know the risks. It's so much safer than having a concern that someone may later pop up seeking access to your child or money from you. So having these agreements is the best way to, before anyone's pregnant, the best way to really prove what the intention was.
See, I look at it through the lens of a family law lawyer, and I can see the cases. You're talking about doing the agreement, doing the right way. I'm seeing the cases when someone comes into my office and says, I want to see the child, and the other side says, no, you were just a sperm donor. Or where the person comes in and says, I want child support, and pay me some money for it. And the guy then saying, no, there was this agreement. And the case then is going to be one of credibility. And then all of a sudden we're looking at old text messages, instant messages, chat conversations, emails, trying to gather what was the intention of the parties. So from a litigation standpoint, I can see there being quite the fight, because if you think about what child support can be and how many years and paying for university, especially if you don't have a relationship with the child, there's a lot of money at stake there. And I know the legislation's only been around a year, and I think there's only been one case on this so far. And I think that was heard in Oshawa. So I'd expect to see that there's more cases coming forward, and that they're really going to be based about the credibility of the two parties and what took place after the birth of the child and why.
Yeah, so that piece about intention definitely still comes back, because that's one of the things that should be coming out in these sessions with independent legal advice, is the lawyers should be saying, you're having this contract, but your relationship with the child afterwards still matters. If you live in another jurisdiction and you never see the child versus you are actually playing a parental-like role, that may affect the outcome of a decision. So that should be part of the advice, so that the parties really appreciate when they're signing what's going to happen after, and the risk of if there is some sort of relationship.
I'm looking at it through the scope of two people who didn't go to a lawyer, and just, one person goes to the other person and says, do me a favor, I really want to have a baby. Can you be the donor? And the guy saying, sure. And then there's no written agreement. And that's where you're getting into what I'm talking about.
Right.
All of the communication. And I'm sure that's going to happen. I'm sure there's going to be a lot of that. Yeah. And then you have the next question of that you raised, is the birth of the baby. Because if I go do that and I know the law in Ontario says I don't, I'm the sperm donor, therefore I don't have to pay. Well, what happens if that baby is born in another jurisdiction that has a different law? And there's reciprocal enforcement agreements for support. So we're at the early stages, I think, of really trying to figure out how it's all going to play out, and what the risks of being a donor are, and the risks of receiving the donation in terms of relationship. I see that the time is just about up right now. I want to thank you, Lisa, because I found this to be a fascinating topic, not just because more and more people seem to be in a situation where they may need a sperm donor or they may need a surrogate, but also from I guess, an academic / law school perspective. There's all sorts of legal questions in here. So it was a pleasure having you on the show today. And for anyone interested in learning more about Lisa and her practice in family health law, you can visit her website at familyhealthlaw.ca. Great website. I know I've been on there many times, and it has a lot of really valuable content. So I encourage our viewers to go on. And our next Ask Andrew show will be May 11th, 2018 at 1 o'clock. If you have any questions or show ideas, please email them to us at info@feldsteinfamilylaw.com. I know I had some emails before the show that people wanted me to cover, but unfortunately, because of time, we've run out of time. Thank you for joining us today, Lisa.
Thanks for having me. Lots more to discuss.